It's for poker.
That's what it was until I started working at IU.
Ready to roll?
Sure.
All right. Where are we going?
Okie dokie. Welcome to the 7th annual Evil Twin Debate here at the University of Richmond School of Law. I am, an hour ago I was Oakley's dad, now I'm Professor Katropia. I need to take off my sticker here. No mystery book reading for you all today. And so we've got a great topic, design patents, great idea or greatest idea. And for those who've seen the Evil Twin Debate before, we've got a format to where we'll laugh some, we might learn something too. And the way we start off with more of the laughing than learning is that to introduce our two distinguished scholars and guests that will be debating this topic today, we ask the other twin, I guess the question is which one's the evil one, right? But the other twin to write the biography for his opponent. So I'm going to read you the biographies written by the opposition. So I'm going to start with the biography of Mark Janis, sitting right next to me. This was written by Andrew Torrance for the University of Kansas, and he specifically says, with tongue firmly in cheek, Mark D. Janis came into the world uniquely suited for today's evil twins debate on design patent law. Though some may have questioned their choice of design as his middle name, his middle initials D. I don't know if really your middle name is designer. Janis's parents knew that this bold moniker would set their son on a path to design patent greatness, though refraining from design patent greatestness. Sorry, okay. Janis studied chemical engineering at Purdue University, received his law degree from the Indiana School of Law, and then practiced patent law at Barnes and Thornburg in Indianapolis. In 1995, he began his academic career as professor at the University of Iowa College of Law, becoming the H. Blair and Joan V. White Intellectual Property Law Scholar in 2002. In 2006, obviously fatigued by the rigorous legal requirements of his standing, Janis accepted the H. Blair and Joan V. White Chair in Intellectual Property Law. After resting in his chair, you've got to sit down, right? After resting in his chair, a reinvigorated Janis returned to the Indiana School of Law to fight crime as the Ira C. Batman Faculty Fellow. Now that's not a joke. It's really
that is real.
Okay, Mr. Batman. However, being an intellectual property superhero also took his toll. Thus, what do we need? We need another chair. And in 2010, he accepted the Robert A. Lucas Chair in Law at the Indiana School of Law, where he sits to this day. And he brought it with him, I think, maybe. It is deeply ironic that despite being a leading scholar in antitrust law and its implications, Janis appears bent on monopolizing scholarly authority in all fields of intellectual property, leaving mere spillovers for the rest of the Intellectual Property Academy. An award-winning teacher and scholar, Janis has written influential books and articles and taught classes on utility patents, design patents, plant patents, and a variety of protections, copyrights, trademarks, and trade dress. His prestigious talents as a scholar, teacher, and colleague are the very definition of unfair competition. Yeah. Mark Janis by Andrew Torrance. So obviously fair is fair. This is Andrew's biography written by Mark. Professor Dr. Andrew W. Torrance is professor of law and docking faculty scholar at the University of Kansas School of Law. Although outwardly a humble man, he prefers to be addressed by his hereditary title, Torrance of Lawrence. However, in keeping with this informality of the present proceedings, he is consented to be referring to as simply his lordship. So Torrance is by far the least evil of all evil twins who have participated in this series. Indeed, he is Canadian, and therefore is under a constitutional mandate of kindness that will be strictly enforced today. Torrance regularly seeks out opportunities for agony. For example, he served as president of the KU Faculty Senate for academic year 2012 through 13. He also holds season tickets to KU football Please indulge him in his need for agony today. Torrance is a leader in the area of biolaw. His official website profile states that his interests in biology have led him to research expeditions to Australia, New Zealand, Fiji, Hawaii, and the Caribbean islands of St. Thomas and St. John. His unofficial website profile states that after the first of his expeditions, he was heard to say, "Screw biology," and switched his research focus to anthropology of beach recreation and the fashion design of tropical swimwear. This explains his fascination with design. Professor Torrance emanates awesomeness and forswears evil. He's kind to animals and children. He generally obeys traffic laws, and he flosses regularly. I guess this truly puts him as the non-evil of the evil twins. Okay, so the topic. We'll actually have a topic. It's not just kind of joke. And it's design, right? And so product design has always been important. If anything, maybe nowadays the way a product is designed is even more important, right? Aesthetics have value. What something looks like has value. What's interesting about design is that design is something that's always been covered by, at least at one time or another, multiple areas of intellectual property law, right? I can cover this intangible through trade dress law or trademark law. I can cover it by copyright law. I can also cover this by design patents. What's interesting, though, is when we think about design, design patents in some ways are kind of late to the party. They've led a fairly quiet life for quite some time until recent years. I have to admit, the first time I've even taught this in my IP survey was last year. I was ambivalent to it, and we joked at dinner that this was always the CLE section that got a little laughs. Oh, we're going to talk about designs, ha ha ha, you know, etc. The one thing, though, about this is that as of late, design patents have become more prominent. The number of design patents being filed has been increasing over the last decade or so. Design patent litigation actually plays front center in your New York Times headlines. Apple versus Samsung. One of the big patents that was at play in that suit was a design patent. And, maybe you believe this or not, I have heard of design patent trolls. We now even have individuals filing for or buying up design patents merely for assertion purposes. So with this renaissance, I guess, actually I stole this out of one of Mark's articles, it's a renaissance of design patents, it begs some questions, questions about scope, right? How broad or narrow should these design patents be? Questions about validity, right? How do we determine if there's enough space between designs to grant protection? And finally, questions of where does this thing sit when we've got three areas of intellectual property crossing over each other? Do we just leave this to the gambit of trademark and copyright, or should design patents sit with that? And thus, the ultimate question this begs is design patents. Great idea or greatest idea? And with that, I now completely lose control over what's going on for the next hour or so. Okay. Mark, please.
Mark, do you want me up there now?
What's that?
Do you want me up there now?
Oh, you can in a second if you want to. Yeah. Well, great. So thanks for the introduction. Wonderful to be here with you. I just a couple of announcements to begin with here. So now that you're here, and more or less trapped, let me just suggest we're going to make two changes to the usual format for the evil debate. Change number one is that it's not going to be that evil. And then change number two is it's not going to be a debate. So other than that, we're sticking with the usual format. So I felt the need to get into this a little bit because I figured if I came here and said that, you know, there's going to be no evil here, you would say, obviously the two of you are well versed in the ways of evil because you're law professors, right? So actually the truth is we looked at the numbers. The numbers tell a different story. Here's what the numbers are. So we looked at all of our course evaluations over the past several years. He's laughing at least, all right? I think it's great, right? And, you know, you can see where we come out here and, you know, there's an evil deficiency. Now, we have worked on this because we knew we were coming here, so we have trained. We sought out evil mentors. We visited evil places and places of despair. Evil and places of despair. And we went to Chris and we got his music collection and we listened to evil music for, I don't know, weeks, right? So the Dolly Parton disco one, that is evil. That is evil. But that's, we're going to have to dispense with much of the evil here, I'm afraid. But Andrew's a little further along than I am on this, I was noticing. So that's the evil part of it. The debate part of it, this is the way we interpreted it. We would be loud and definitive and without any heed for the accuracy of our statements. So it was kind of like ESPN commentary, except not about sports and nerdier, and millions of people will not be watching it, but otherwise, much like ESPN. So I do have actually a point about that, if I can remember what it was. The point is that actually in design patents, especially in scholarship about design patents, the debate really has not fully crystallized. And that's part of the reason that we're changing the format a little bit. Here's what you have to understand about design patents. You got a little bit about that just a minute ago. For many, many decades, design patents as an area was viewed as kind of a trivial backwater of intellectual property and more or less a kind of a repository of the weird. And this design patent might indicate that that's in some respects still the case. I've obviously passed the 3-joke rule into the 4th joke, where the laughter doesn't. I like this one because the head there is Chris Catropia's head. And it's rendered in dotted lines, meaning that the head is not part of the claim, so you have no fear. It's okay. Yes, right. So it still is a little bit of a repository of the weird, but clearly it has a much higher profile today than it had for many, many years. That's mainly because of the Apple versus Samsung case, the $1 billion verdict, which you can see scribbled on the verdict form there, and maybe even the fact that it was so important that it was mocked by Stephen Colbert. So design patents have obviously arrived, but indeed the debate, the scholarly debate over it is still in its infancy. And so what you're going to hear today, in contrast to some of the other evil twin debates that we've had here, is not so much a debate about doctrinal refinements in a kind of a nuanced or a more narrow way. There really are fundamental questions about the design patent system still in play, and that's what we're going to be going through with you today. To understand that, you need to understand a little bit more about the system, and so let me talk a little bit here about basic premises of the system. And where it starts is with this idea that you could take rules developed from the invention patent system, the utility patent system, and somehow adapt those to protect visual aspects of industrial products. And so what you see up here is Commissioner Henry Ellsworth in his report, the 1841 Commissioner's Report, where he just, after a certain amount of debate in Congress where it kind of looked like this was going to be a copyright for design system, Ellsworth comes in and he says, you know, it would just be easy to meet this objective of promoting progress in the decorative arts if you would just borrow the rules from utility patent law and protect them as this design patent and send them all to me, the Commissioner of Patents, and the filing fees would then come to me, Henry Ellsworth, the Commissioner of Patents, and then we should just do it that way. And Congress went along with it. And leaving us even, that's 1842, there's still this fundamental question of whether that was a good idea. And that's really what we're going to be talking about for the rest of the time here. Was it a great idea? Was it the greatest idea? Was it just kind of an okay idea to do this wholesale borrowing? And that's the way his idea was implemented mainly through a wholesale borrowing with a very few specialized rules to govern the system. So I've got the statutory language, or at least some of it, on the slide for you there, the modern statutory language. And what you see underlined up there is really the embodiment of Ellsworth's idea. It's an incorporation clause, so saying that, you know, unless otherwise specified, rules from utility patent law are all going to feed in here. There's a few other provisions there, a priority thing, a provision about term, and a special provision about remedies, but that's really it. Those are all the design patent provisions, all right? So simple idea, was it great, was it greatest, was it, you know, whatever. Let me tell you a little bit more about how those rules have been implemented, and then we'll start through kind of a faux debate, I guess, kind of a non-debate, a non-evil non-debate is what it'll turn into here. So just a couple of things you need to know, I think, to sort of get a framework for the questions that we're going to debate here. First of all, rules that were incorporated from patent law. One is the fixed and relatively short term. 14 years, gonna be 15 years after the international agreement's implemented, but 14 years, relatively short term, so very different, for example, from copyright and trademark. Patentability rules depend fundamentally on patentability over the prior art. That is, of course, really different from trademarks. No secondary meaning requirement, for example, here, all right? So we can talk more about that. Scope rules depend on or start from the existence of a patent document that would seem to have claims, it would seem to have disclosure, and you proceed to determine infringement and to proceed to determine scope really by fixating on that document. That's a little bit different at least from copyright and trademark law. Those are all rules incorporated over from patent law. There are some design-specific rules. There's an ornamentality requirement that we'll talk a little bit more about. There's an article of manufacture kind of requirement as part of the eligibility rules. And then there's this special rule for recovery of profits in addition to other remedies that you might have, all right? So that's the overall snapshot that you need to have in mind as we turn to this fundamental question, was all of this really a good idea or not? And great versus greatest, you want to give an illustration of great versus greatest before we start into these? What we're going to do here is take these doctrines one at a time in a sort of a thumbs up, thumbs down, thumbs sideways kind of a way. If I had a timer, there'd be a timer going off. It really would be a whole ESPN kind of thing, but we couldn't be that elaborate. But that's what we're going to do, and all of this is to elicit answers to the question, great versus greatest, and distinguish between the two. You brought a prop with you. You want to?
Yeah. So we wanted to make sure you understood that we understood what the debate was meant to be about, and that we do understand.
I don't think we really did.
I think we really did.
No,
we disagree. We disagree. Yeah. Yes, we did. No, we didn't. We understand the difference between greatest and great, and perhaps the best way to illustrate this is to say that St. Louis had a great baseball team. They really did. They had a great baseball team. Anybody here from St. Louis? Anybody here cheer for St. Louis? But, you know, the Boston Red Sox had the greatest baseball team. So we just want to make it clear. We do understand what this is about. Now, we've chosen to blithely ignore it. But it's too late now, isn't it? I mean, we have the floor. They're sitting there. The tape is running. So I think we'll just continue.
I don't necessarily endorse that. I don't have my Chicago Cubs keychain with me, but that's neither here nor there. So this is what we're going to do. We're going to start off and we're going to talk about patentability rules. Great, greatest, okay, brilliant. We're going to talk about scope rules. We're going to talk about some of the other rules that, eligibility rules, I guess, are in there, that collectively define what the patent system is. And so I'll start. I'll give my view on thumbs up, thumbs down, thumbs sideways on these, and Andrew's going to give his. So first off, patentability rules. So here's what I want to say about those. So kind of good. It's good that there's this discipline of comparing claim subject matter to the prior art, specific instances of the prior art. That's good. All right. Otherwise, bad. Bad because of obviousness, all right? So obviousness of designs is bad. It's bad because not historically well-grounded, because the obviousness doctrine was not fully formed in 1842. Ellsworth probably had no idea there was going to be an obviousness criterion. Judge Rich said, obviousness in connection with design, it's incongruous. He said it's impossible, right? It's just a weird thing to think of obvious design. Most importantly, and the main reason why it gets, I think this is coming up next, right? Yeah, thumbs down from me, all right, is because the doctrinal implementation by the Federal Circuit of the obviousness criterion for designs is very clumsy. It's a discrete, it's a two-part analysis. It requires you to very precisely identify a primary reference, makes it very hard to identify that, combine it with a secondary reference, really hard to knock out a design patent claim for obviousness purposes, and it's not getting any better. If you look at Apple versus Samsung, it was really hard for Samsung to get some of their prior art identified as proper primary references under this test. That's bad, all right? High Point Design, which is a new case from a few weeks ago, it has to do with slippers. The court makes it even worse by saying you have to offer this verbal rendition of these designs as a predicate to engaging in this obviousness analysis. That's going to make it really, really hard to do this fundamental comparison, which really should be a comparison between pictures. Many other reasons why obviousness is bad, but let me turn it over to you.
Yeah, let's skip forward to the next thumb.
So you say...
Yeah, so
all right.
I'm a little more sanguine about this. I don't think that the rules are very good right now. I think they can be improved. I think one of the big problems is that these cases come up for appeals so seldom that it's hard to build up a body of law. I tend to see some of the difficulties that Mark sees as maybe ameliorated with time. Take KSR, for example. I don't think KSR principles have really, if there are principles in KSR, have filtered into the design patent realm, in part because it hasn't really been squarely looked at by the Federal Circuit yet.
The Federal Circuit is resisting them even.
Right, they're resisting them. But I think that that's partly because you don't get a high frequency of design patent appeals. Now, there's many, many more utility patents out there than design patents, but I think as time goes on, we may get some improvements. I'm not enthusiastic about obviousness, but I think that I'm a little more optimistic that we can improve from where we are.
Yeah, it is hard to tell what you would replace it with, or if you would just kick it out. That really is a really difficult question in all design protection systems. And if you look overseas, there's not really a better alternative either. So I have to say that in fairness.
And I want to also mention that obviousness is generally a disaster in utility patents too. Yeah, so to tar design patents uniquely is probably unfair.
True enough. Okay. So that's a little bit on patentability, all right? So let's go to scope. Rules of scope, and of course this could cover lots of different types of rules. I'm going to focus on 3 areas here. So area number 1 is claim construction, area number 2 is rules of infringement, and then I'm going to slip in the rule of functionality, because in design patents, functionality plays 2 roles. One is potentially as an invalidity doctrine, but the other one is to narrow scope. So I'm going to talk about that a little bit. So 3 things. So first of all, understand here that in a design patent, the drawing effectively is the claim. Same thing, all right? So if you start talking about designs and patent protection and this document where the drawing is the claim, you start off, you have claim construction. And when you talk about claim construction in the design patent area, you're talking about some kind of construction of a drawing. And this has led courts to all kinds of problems. 2 in particular. 1, literally, in some cases, they've been tempted to substitute 1,000 words for the picture, rendering these elaborate verbal constructions of a picture and thereby narrowing the scope incredibly. All right, that's problematic. Thing number 2 that's problematic is that it sort of leads you to an element by element way of thinking about design subject matter, which is totally wrong. it's supposed to be protection for the overall visual impression, not for individual elements that comprise the visual impression. Anytime you get a patent lawyer starting to think about claims, you got this element by element problem. So that's a problem. Second problem so that gets a downward thumb for me. Claim construction, bad. The Federal Circuit, should I do that? Oh yeah, okay. So that's the first downward thumb. Now the Federal Circuit has tried to deal with this, and it's getting better. It is getting better. Courts are not rendering those verbal claim constructions quite as often, but they're still stuck on an element by element mentality. So that's why I say down.
But it wouldn't be hard to get better, would it?
It wouldn't be hard to get better, yeah. So, second thing, infringement rules rely on a concept of the ordinary observer. That's a good rule, except that the infringement calculus is very complicated because it requires a comparison between the patented design, the accused design, and then in most cases, in light of the prior art. And this three-way design is supposed to be done by the hypothetical ordinary observer, who is thereby not anyone even remotely sort of similar to a real-world ordinary observer. And there's some tensions. That's at least a sideways thumb, all right? The real problem in design patent scope, potentially at least, is the Federal Circuit's treatment of the doctrine of functionality. So the basic concept is very clear. You're trying to protect visual impression, not function. And so if the visual impression is truly dictated by the function, then you may have a problem, right? That's the way I would think about this concept of functionality, and it's a totally solid concept. It's a very difficult issue in any kind of design protection regime. The problem that the Federal Circuit has gotten into with the functionality doctrine in design patents largely emanates from a few cases in which the Federal Circuit has begun to talk about functionality of individual features of an article. And all of these are industrial articles. Of course, individual features perform functions, and if you start running down that path, pretty soon nothing is protectable by a design patent. Everything is composed of features that do things. Now, the Federal Circuit at one point had recognized that. So there's a case called Avia Group. It's from the 80s, involves shoe patents. And the Federal Circuit said you can't do functionality on an element-by-element basis. They said a distinction exists between the functionality of an article and the functionality of features thereof. And if that weren't true, you could never get a design patent on anything, all right? The Federal Circuit seems to have forgotten about that in a case called Richardson, where the court said, trial courts, you're supposed to factor out features that are functional on a kind of seriatim basis, and then you end up like there's nothing left after you do all this erasing and factoring out. So that's a thumbs down right there. Now, small sign of hope, High Point design case, the one with the slippers, the trial court had said this. The trial court said, well, it's a slipper. The slipper covers the foot. That's a function. So the exterior part, that's got to be factored out. The interior part, the fuzzy part, it keeps your foot warm. That's a function. So that has to be factored out. And that went up on appeal, and the Federal Circuit said, you can't do that. You're factoring, those are all just, of course, those features perform function. You're supposed to be looking at the visual impression of the overall design and whether the overall design's visual impression is dictated by function. And in this High Point design case, they cited the Avia Group case, and they ignored the Richardson case, conveniently. All right? So maybe there's a sign of hope there in High Point design, but I'm waiting, and so I still say down. All right? What do you got? So shall we go to yours now?
Yeah, absolutely. So I agree. Yeah, I agree on the first one. I have nothing more to add on that. The second one, I'm even more pessimistic. I think that it's a very problematic analysis. The third one, I'm going to hold my fire for a minute or two because I have something to add to it, and I think I have a more optimistic way to look at the third factor. But I'll wait for a second.
But you're going to wait? Yeah.
I'll wait for a second to do that. That's what the ... is for. Mark didn't seem to understand that, but hold my fire for a second. But 2 thumbs down on the first 2. On the second factor, take Mark's reasons and put a frown on it. I think it's even more serious problem than he's more optimistic on that than I
Yeah,
am.
yeah, okay, fair enough. All right, so next subject that we wanted to talk about briefly is eligible subject matter, eligibility rules. And the rules are formulated in a really simple way. It just says it has to be a design for an article of manufacture. There are some advantages to this, and I'm stealing this argument really from Andrew. The one advantage to
That's
it.
evil, Mark.
That is evil. I liked it. I heard it and I liked it. I said, I'm going first. I'm going to steal it. What Andrew said, and it really is right, is that formulation, like the broad categories in the utility patent statute, section 101, does allow for a lot of flexibility and allows courts to take these on a case-by-case basis and not have to constantly go back to Congress and refine different categories. That's good. The flexibility that allows for sort of unforeseeable sort of jumps in technology and design innovation, that's good. All right, that's helpful. What's so-so, but I'm still going to go with thumbs up because I think that's, I hadn't had any other thumbs up. I'll go with thumbs up on this. The notion of the article of manufacture is a little bit problematic for a certain class of really important designs, and that's designs of what I would call virtual designs, designs of icons, generated images, some of which were at issue in the Apple versus Samsung case. The problem is that it might be sort of hard to conceive what the associated article of manufacture is, and more importantly than that, the appearance of that article, that associated article, shouldn't really matter. All right, so if Apple comes up with an icon for iTunes, I mean, it really doesn't matter whether it's on something that looks like an iPad, something that looks like an iPhone. That doesn't have much to do with the design qualities of that iTunes icon. The problem is, how do you convey that in a design patent? The way it has been done historically, and then I'm going to let Andrew take over here, but the way it's been done historically is to think about designs that are surface treatments. Those have been protected for decades and decades and decades. And so wallpaper designs, rug designs, all those are surface treatments on an article where the appearance of the underlying article doesn't really matter. And the lawyer trick that's been permitted is to represent the article by dotted lines indicating that that's not part of the claim. And that's been the solution, as Andrew will explain, that's been the solution for eligibility for graphical user interface designs. But that really hasn't been tested in the courts yet, and it's going to be kind of interesting. I'm giving it a thumbs up because I'm confident the court's going to do the right thing there, because I think those should be eligible. But we'll see. I think Andrew maybe is not quite as confident they're going to do the right thing. So you got some things to say about this. You want to?
Yeah, absolutely. So this is a good jumping off point for me, in part because he's basically talked and talked and talked.
Yeah, I know.
Good jumping off point for you as well. Mark is.
Leaving now. I'm just going to be leaving right now.
Well, don't cry. It's okay.
Evil Boston Red Sox fan.
I think I'm not as optimistic, but I do think that there's some really interesting doctrine here and some really interesting changes in doctrine that illustrate some of what Mark has been talking about. And so I'm going to talk about two doctrines. First, the ornamentality doctrine. So ornamentality is closely related now to functionality, and Mark talked about functionality. Long, long ago, almost from the beginning, there was apparently an aesthetics component to design patent law, an aesthetics requirement. If you go back to Gorham v. White, one of the granddaddies of Supreme Court design patent cases, they talk about how there has to be something that helps sell the item, something that's not functional, something that must be attractive in some way. They don't use the word aesthetics there, but aesthetics comes in later cases. So for example, in Blisscraft in 1961, the court says a design must be the product of aesthetic skill and artistic conception. So this is a pretty bold statement for a court to make. You know, roughly the same time, courts are grappling with the idea of what obscenity is. And I think you'll probably agree in 2013 that of all of the parts of society to judge things like that, judges may not be the right repository of aesthetics and skill judgment. And I think in many, many other areas of the law, judges have realized this. But we have this concept in design patent law which explicitly calls out aesthetics. And what is sort of funny, I think we both agree, is that the Supreme Court in 1989 in a case called Bonito Boats comes out and says this, even though at this point the aesthetics doctrine is more or less dead. They don't realize that yet. And they don't say it, it's just dicta in the case, but they have this nice aesthetics statement: to qualify for protection, a design must present an aesthetically pleasing appearance. Must present. That is not dictated by function alone. So there's an element of where the law is going here and must satisfy the other criteria of patentability. Well, the Court of Appeals for the Federal Circuit, in the meantime, and before this 1989 case, had been undermining this idea of aesthetics. Almost from the outset of the court, they thought this was a problematic requirement. Not just problematic because maybe they shouldn't be making the decisions, but also fundamentally weird for them to be deciding that question. And so they pivoted the doctrine towards not strictly dictated by function. And there's a nice quotation from the Newcoat case in 1999. Nor need the design be aesthetically pleasing. This is totally contrary to what the Supreme Court says later. The ornamental, in quotation marks, requirement of the design statute means that the design must not be governed solely by function. This, I think, shows the adaptability of design patent doctrine, and I think this is a strength. You mentioned this already. I think this is a strength of design patent law. It finds a way around obstacles, and it shows an ability to adapt to more modern circumstances. I'm going to show you now a brief graph of a study that I've done to look into this requirement. And this is a little bit counterintuitive, but essentially what you see in this graph is that early on, during the tenure of the Court of Appeals for the Federal Circuit, early on, it mattered whether a design was aesthetically pleasing, because if it was not aesthetically pleasing, it would be treated badly in court. It would either be found invalid or worse. But as time goes on, according to an experiment that I ran, as time goes on, the requirement of aestheticity, aestheticness, it degrades to the point now where if you have a really, really pretty design versus a really ugly design, the court turns a blind eye to that and they look at the functionality. Is there a dictation of function or not? So I see this as a strength of the doctrine, but it's also a sort of remarkable change towards functionality, away from aesthetics towards functionality. Another thing that I want to mention, the other doctrine that I think has been remarkably adaptable, maybe not coming to exactly the right result yet, is the article of manufacture requirements. Mark pointed out, this is right there in the statute. Article of manufacture. This is sort of the base thing upon which the design must be, or that the design must be. So in 1888, this was defined as something made by hand, a manufacture, literally something factus by manos, made by hand. As time goes on, what's that? You don't like Latin?
No, that's okay, Don.
It can be very useful, especially in the law.
Never heard of that before.
So going forward, gradually the standard of what can be included is loosened. So roofs qualify as articles of manufacture, grandstands qualify, and even a fountain. This isn't the exact fountain, but I thought this was a pretty fountain, aesthetically pleasing, if you will. In In Re Ruby, I think the court that preceded the Court of Appeals for the Federal Circuit, it really makes a step forward in loosening what can be covered, because it's the pattern of the water. Now, is a pattern of water an article of manufacture? I think this is a legitimate point of debate. There's a dissent in the case that says absolutely not. I mean, water, as soon as you turn the nozzles off, the water's gone. This is ephemeral. So why is this relevant today? Well, it turns out that computer-generated images are worth a lot of money to a lot of companies. And you use them every day, on your phones, on your computers, etc. back in 1988, Xerox actually received a couple of computer-generated image design patents. But in '89, the commissioner decided, naughty Xerox, you can't get design patents on those for a variety of reasons, including the fact that they're ephemera. They're not imprinted on the surface. There's no physicality to them. They're not articles of manufacture. That was, I think, part of the rationale that the commissioner's thinking of. So made a rule, can't do it. Can't get design patents on these things. Well, you can probably think back in the history of computing, they become more and more and more important. And a number of cases start to struggle with the rising demand for protection for computer-generated images. And in 1996, after some interesting events that are beyond the scope of this debate, the Patent Office decides to reverse itself, and they issue guidelines for examination that say, actually, you can. And they come up with a variety of rules, including dotted lines and things like that, little tricks, so that you can, in fact, protect computer-generated images. And this is even before the icons on smartphones and iPads. Well, what's interesting is that this has never been tested in court. And obviously the Patent Office, you know, the arbiter of these decisions, can't seem to agree even within itself. You know, is it a no? Is it a yes? Why did it change in '96? There is one case which has looked into whether you can protect, using design patent, computer-generated images, and that's the Adobe Systems case versus Southern Software. And some people point to this and say, see, the issue is settled. I disagree, because the subject matter of the design patent that was at issue here was a font. It was a font that appeared on a screen. Well, why is that significant? Because as Mark knows and has mentioned in some of his works, the very, very first design patent, literally D1, was actually a design patent on fonts. And so the fact that this case actually was about fonts, I think, takes it a little bit out of the mainstream of whether the issue was computer-generated images. The court may have been comfortable with the fact that fonts have always been design patentable since 1842. So I think it's still an unresolved issue. I think this is a little bit dangerous for the future of companies that are investing billions of dollars in design patents. And I think really what design patent ability is waiting for is its own Chakrabarti. It's waiting for some determination by a court about what, generally speaking, is protectable and what's not. Specifically, computer-generated images, I think, will drive that train. Now, why don't we have a Chakrabarti? Well, this is sort of interesting. Imagine who owns design patents. You know, Apple, Samsung, Microsoft, companies like that. Why would they ever want to challenge the eligibility of design patents on the part of an infringer when they own vast quantities of design patents, which are premised on the fact that they consider them patentable? So I think that this is an unstable part of the doctrine. I think that it would be valuable to settle it. I'm not sure which direction it'll go in, although I suspect that the court will embrace a broader idea of patentability rather than a narrower one.
And so that leaves you, you're sideways on that, right, isn't it?
Yeah, I'm not quite as optimistic as you are, but depending on what sort of treatment it gets in the courts or in Congress, I think it could improve. I think there's room for improvement here.
Yeah, so that's an interesting area. My co-author Jason Dumont and I have an article called Virtual Designs that's coming out in print that studies this phenomenon. There's probably, when we looked at it last, there were 7,000 of these design patents have been issued, and it'll be really interesting to see what the courts do with them when, as I think, eventually they're going to have to squarely reach the eligibility issue. Okay.
Yeah, I also have a paper on this. I think it's coming out in the same journal, right?
Oh, and yeah. So yours.
Yeah, with a gentleman named Bill Seymour, who's a practicing attorney. He runs the blog Ordinary Observer. So he and I trace the history of the article of manufacture requirement, and we make some predictions about where it might be going as well.
Yeah, those come out in the same symposium volume.
That's right. Yeah.
All right, so just a couple of things that we'll say to wind up then. So one other issue that I think we'll talk about just briefly is design patent rules that relate to remedies. And it's just worth mentioning because the rule is unusual. It allows you to collect profits from the defendant, which is unusual. And the profits, explicitly in this special provision of the statute, the profits are tied to sales of the associated article of manufacture. And you might say, well, in some cases that would make sense if it's, if it's the design of a Volkswagen chassis and it's the sale of the Volkswagen, that sort of figures. In the surface treatment cases, it's trickier because you would say, so wait a minute, what you get to collect for an infringement of the design of the iTunes icon is going to be based on sales of the iPad and the iPhone. I mean, that just seems like that's got to be gross overcompensation, you might say, and people are beginning to argue that. On the other hand, if you say, well, it's really just all about deterrence, and it's these design patents are really used against counterfeits, it might be useful to have a provision like that. And the reason that this provision originated was that there were cases on carpet designs. And these cases, there was clear infringement, and the court literally said, okay, you get 6 cents or some trivial amount. I think it really was 6 cents for that infringement. And then Congress came in and said, well, this isn't fair, right? These design patents would be entirely worthless if that's going to be the rule for compensation. So they constructed a provision that allowed for the collection of profits, but at the time it said that it was only for infringements that are willful. The willfulness criterion has fallen out in the modern statute, and I think that there's going to be arguments about putting it back in at the very least, if not reconstructing it altogether. I think that leads me to be sideways thumb on the remedies provision. Did you want to add to that? I think we're kind of in agreement.
Sure, yeah, go ahead to my thumb here. We differ on this one. Yeah, so I'm a little more optimistic about this. Mark alluded to this. I think this is a useful provision for counterfeiting, and counterfeiting may actually be where the rubber meets the road here. Exact copies. There's a lot of good reasons, I think, that we want to deter exact copies of people's designs. And I have a feeling that in practice, you're not going to get a lot of the abuses that you could get, that in fact it will mostly be used against counterfeiters. Now, that said, I agree with Mark that it would be nice to clarify which cases are actually covered by this provision, which cases are not. Right now, I think there's too much ambiguity, but I have a feeling that courts would deal with that by being in favor of applying it for counterfeiting more than other cases.
All right, so let's conclude then. Overall assessment here. Was it a good idea at the end of the day? Was it a great idea? Was it the greatest idea? Was it whatever labels we're using? To borrow utility patent rules, and without a lot of addition of specialized rules, to use those to protect designs. To me, it's a hard case to make that was brilliant. So I'm going sideways on that one. I can see some advantages. I wouldn't want to see this system dismantled. I actually think there's something to be said for rules that would channel innovation toward that system, and possibly even toward it, even away from trade dress and copyright, if you really insisted on that. So I think that there's a reason for the system to exist. I think it's an okay system. I think it's not necessarily inferior to other models of design protection, such as the community design system that exists in Europe. I think it's got a long, long ways to go. At the end of the day, I'm not sure that I can say it was brilliant to try to adapt these utility patent rules. I think it's a hard, hard task. And whether it's ultimately worth it, or whether you would just as soon start from scratch with an entirely new set of rules, I think that's a close call. So I end up saying, for that reason and a variety of other historical reasons, I end up saying, okay, maybe even great, but not all the way up to greatest. All right, so that's where I come out. You're happier.
Yeah, so I'm a little happier about that. Oh no, that's okay. I think that today especially there's more emphasis on good design. I think this is exemplified by some of the ideas that people have been attracted to from Steve Jobs and others, that there really is a value to taking principles of good design and applying them to things that in the past were functional and worked just fine, but once you apply good design principles, in some ways they transcend what they were before. I was skeptical of the iPad before it came out. I made jokes with everybody else, but now I'm a true believer. I love my iPad and you know, all sorts of tablets like that. I think that's the result largely of good design rather than good function. I think you know, the function's related as well. I think there's a value in good design, and I think there's a large movement now, especially in technology products, towards improvements in design. Take something as banal as the thermometer, or not the thermostat in your house. Whoever thought that a thermostat could be really, really nicely designed? Well, Nest has designed a thermostat that is actually quite cool. I don't know if any of you have ever played with a thermostat. It's almost as fun as playing with an iPhone. It's really kind of cool. Good design, that's what did it to the thermostat. I think it's going to do it to a lot of other products. I see that as a societal good. I think that design patent law has a set of liberal eligibility rules. I think this will be clarified when we get our design patent Diamond v. Chakrabarti. But I think that those liberal eligibility rules have accommodated changes in technology, including important changes like the transference of design from the physical realm to the virtual realm. I think that in general, it's shown remarkable doctrinal adaptability. And I think adaptable law is often better than static, unchanging law, because society changes, conditions change. I'm not saying the law should be a ball of wax, but I do think that it should accommodate changes that are otherwise thought important in society. Now look at some practicalities. Applications and grants of design patents are rising rapidly over the last decade or so. Efficiency, if you want to get protection for your design, this is a really nice system from an individual's perspective or a company's perspective. There are modest application requirements. A really nice drawing is just about all you need, plus some fees. Speedy prosecution. You don't have to wait 6 years to get your patent. You can get a design patent in a year and a half, and that's not super fast. And they're relatively inexpensive. You don't have to pay $15,000, $20,000 for a patent application. It's a fraction of that. And then I think that they're valuable. I think they're objectively valuable. I'm working on a project right now looking at valuable patents in portfolios that companies have. And one of the things that struck me, one of the things that surprised me, is how many design patents come out near the top of the crown jewels of companies' patent portfolios. Because design patents, there's very few of them. There's only about, just under 700,000 at this point, I think. And there are more than 8 million utility patents. So it's remarkable to see so many D patents at the top of portfolios. So I think companies see them as valuable. And they're increasingly litigated. So taking a page from the Lemley and Allison idea that highly litigated patents may also be valuable patents, we're moving into sort of a, ironically, golden age of design patent litigation, indicating that folks out there consider these things valuable enough to fight over them. And so I think, in general, we come out, your way you would interpret as okay to great. Would you agree?
Yep.
Okay, and I come out a little bit more than that. I think, greatest with a couple of little footnotes there. Greatest, and I'm hoping for even greater than greatest, whatever that is. Yeah.
Since we're a law school and we want our students to go to class, not that this is not education.
Yes, right, but you got to go.
Let's go ahead and break, and if those of you who go to class, we've got refreshments and food outside, and you can ask questions personally, right, to our two evil twins. Thank you again, Mark and Andrew, for coming and joining us.
Thanks very much.